After weeks of turmoil that's pitted Edward Rogers against family members, other directors, and the company's CEO, a judge is about to decide who's calling the shots at Rogers Communications, just as it's trying to close a $20 billion takeover of Shaw. This is what it all comes down to for investors. Special coverage of Rogers versus Rogers, The Decision, starts now. Hello, I'm Greg Binetti. Welcome to our special coverage of the Rogers versus Rogers case, the family fighting for control of the company. We're expecting a verdict at any moment. Now that we have crossed the threshold of 5 p.m. Eastern Time, we will bring it to you, of course, as soon as it is delivered. Our Paul Bagnall is in the courtroom and live tweeting. We're going to have expert insight and analysis of the decision, what it means for the company, and what it means for the shareholders. As we await the decision, joining us now, Michael Binetti, the managing partner of Affleck Greene McMurtry LLP, also joined by Richard Leblanc, a professor of governance, law, and ethics at York University. Gentlemen, thanks for joining us. Of course, you know that at any moment I could break in. We probably won't get the decision that quickly, so let's just sort of hash out some of the issues here. I want to start with you, Michael, from a legal perspective. I mean, the key question here before the court to answer is, does Mr. Rogers have the authority here? Does Edward Rogers have the authority, just with a stroke of a pen, to replace the board?
Well, the BC Corporations Act gives people like him in a position like that ostensibly the authority to do that, because it says as long as you have the majority of the votes, and if there's no actual meeting, as long as you have a supermajority of the votes, then you can do that without a meeting. The issue before Justice Fitzpatrick was to the extent a meeting was required or not whether or not you can do this.
Okay, so that sets us up for a very interesting bit of intrigue heading into this. Richard, I want to ask you from a governance perspective, even if the court does find that Edward Rogers was within his rights to do this, what does it tell us about corporate governance in this country?
Well, it tells us that corporate governance needs some work. And what the counterpoint is that this is not good corporate, and this is what the family and Rogers have argued, that this is not good corporate governance. You have to have a meeting. And that you need to respect the wishes of Ted Rogers, who wanted a meeting, a shareholder meeting, to face the gauntlet of shareholders. And also he wanted earnest consultation, were, I think, his words. So counsel for Rogers has used Supreme Court cases to almost compel the judge to when in interpreting this section, to bring in good corporate governance and to bring in the wishes of Ted Rogers. Whether that will be successful or not, as Michael correctly pointed out, he appears to have the authority. When you look at the Act and when you look at the article that 3.4 that Edward Rogers is relying upon.
Now, Mike, I want to throw it back to you. If Edward Rogers does not get the order that he's seeking here from the petition, it just seems like a timeline issue, right? I mean, the quickest resolution for Edward Rogers is for the court to side with him and give him that declaration that he is seeking today. If he doesn't get that, as the chair of the Rogers Family Trust, it seems like eventually he will get his way, and just on a longer timeline.
It's I've always thought this is just a question of timing. It's not a matter of if, it's just when. Because if the court says that he needs a meeting, well, he's got the family trust can call a meeting, and they've got all the votes at that meeting. So if it's just a matter of going through the motions, then that may be ultimately what happens.
What can we expect by way of appeal here as well? I mean, there's going to be one party that is not going to be pleased with the outcome. Is there a continuation of this legal saga after today?
Well, there's an automatic right of an appeal. We have a very seasoned trial judge who's been sitting on the bench for 20 years who practiced commercial litigation. So I expect whichever way she decides may be hard to appeal in the end, but there is a right. The real issue is going to be, will the Court of Appeal or even her Honor grant a stay of that ruling until the appeal is heard? I don't think that's likely, but that's possible. I'm sure either side whoever loses is going to appeal and is going to ask the court to stay or stop the decision that was made.
Gentlemen, we are getting word from inside the courtroom that apparently we're facing a 20-minute delay, so it looks like 5:20 p.m. Eastern time, so we can let our conversation breathe a little bit on that front. It's not imminent. Richard, wanted to ask you too about in terms of the way forward for Rogers or for any other company, because we've had this problem. It comes up time and time again in Canada about family control, about dual-class shares, about proper governance, but we've seen a real push recently in terms of ESG, in terms of a greater governance, a more diversity of governance. How does Rogers navigate beyond this, no matter what the decision is?
Well, I wanted to pick up on what you said and what Michael said, that what happens if there has to be a meeting. You know, it's not a foregone conclusion that if there does have to be a meeting, that Mr. Edward Rogers won't change his mind. And bringing in some of the things that you just mentioned, Greg, about ESG and diversity and good corporate governance, and also the Shaw merger. We have pushback from Bell and TELUS, and they are arguing that the CRTC should delay its hearing of the Shaw-Rogers merger. And if, in fact, Mr. Rogers is able to replace all the directors, I'm not sure a regulator acting in the public interest would be keen to approve a merger with one king of the castle. So if there is a path forward in this, it's to try to broker a compromise and really talk about the best interests of all shareholders, including institutional shareholders, retail shareholders. So I see the path forward as being a ray of light, if you will, if there is a meeting, and for all sides to get together. And it just gives us some breathing room, not just the 20 minutes now, but what Rogers needs is really a month or two to cool down and try to work this out and try to bridge fences among the family members as well.
Okay, Michael, what do you think about that from a legal perspective in terms of mending fences among the family members, having a little bit of a cool down, because things have gotten pretty heated? Is there a resolution here where perhaps members of that family who are so divided at this moment can get around a table and figure this out?
I would say if the other side, the losing side, appeals and somehow gets a stay and nothing can happen until the appeal is heard, then for sure I can see a big push for them to get together to try to work it out. If, on the other hand, someone asks for a stay and they don't get it, then it kind of hands a bit more leverage to the other side to just plow ahead. So it may turn on what happens on the appeal.